May I please, Your Lordship?
Yes.
My Lord, I beg to mention items 4 and 5. With the consent of the both parties, may I pray that this matter may be fixed after 4 weeks. Item 4 and 5.
Otherwise, affidavits filed.
I have filed my affidavit in opposition.
Your Lordship, I may pray for, on behalf of KV. I'm told that, in fact, the other respondent are the main party.
4 and 5 are the main
State
contesting
is
parties.
pro
Yes,
forma,
yes,
perhaps.
yes.
Her learned counsel for the petitioner Pong Jamir, who prays for listing the matter after
4 weeks.
4 weeks. Oh, not petitioner, respondent.
Respondent.
Respondent number
4 and
4 and 5. Prays for listing the
Oh,
matter after 4 weeks. So, learned counsel for the petitioner is present and has no objections. List after 4 weeks is prayed for. Yes.
Maju Pala.
Goes on.
For item number 4.
Yes. Who's there?
Ma'am Livika.
Livika. Where's Livika? Respondent number 5. Who's appearing for respondent number 5?
Your Lordship, here
Livika
in
was
the second
appearing.
petition, we have only 2 respondents. Page number 2 and page number 4.
Page 3 and 4.
Yes, my lord. Respondent 1 and 2. We have only 2 respondents here.
Okay, so Livika is appearing for all the respondents?
Yes, my lord.
Where is she? Livika is around. This is a contempt petition. She's appearing for all the respondents here. She was supposed to get some instructions. Learned counsel for the petitioner, Ms. Such and Such is present. Learned counsel, Ms. Livika, appearing for the respondents, is not present when the matter is called. The counsel for the respondent was instructed on 5/6/2026 by this court. Yes, Livika. What instruction?
Your Lordship,
Respondent 5 now has to do the needful.
Your Lordship, the C has already put up the matter before the Commission Secretary for release of the work charge. Proposal has already been sent, Your Lordship. So
It is regarding that migration, isn't it?
No, no,
Migration
merged
of
already
work
be done,
charge
Your
to
Lordship.
category A.
That
And
is already-
petitioner's name figures at serial number 19. Okay, then.
merger is already done,
Okay,
Your
that is
Lordship.
already done.
Now it's
Yes.
only with regard to payment, Your Lordship.
Okay. So you're seeking some more time.
Yes, Your Lordship. Some sufficient time, Your Lordship, because
Shall merge such and such so that clearance can. Oh, for the salary.
yes, sir,
For
already
the
said,
salary.
sir.
Okay. How much time? 1 month.
Your Lordship, actually they are requesting for 3 months because they need to have a clearance, but it's up to the court, Your
That is
Lordship.
too much.
Or maybe a minimum of 2 months, Your Lordship.
Yes, what did I say? Learned counsel petitioners are in charge present. Na? So, learned counsel for the respondents, Ms. Livika, is present and has produced a copy of the proposal which has been sent to the government by the respondent number 5, isn't it? By the respondent number 5 /
Your
Chief
Lordship.
Engineer, PWD RNB, regarding release of the work charge staff backlog salary.
Yes, Your Lordship.
So, learned counsel therefore submits that they may be given another 3 months time to comply with the direction of this court fully and to release the said backlog salary. Stop. In view of the fact that this matter has been pending since 2025, and the direction of this court is
24/7.
was passed on 24/7, na?
Yes, ma'am.
24/7, 2025, comma. The respondents are given another 60 days to comply with the directions and to fully release the backlog salaries. List after 60 days. Yes. By that time you have
Yes, Your
to
Lordship, I
furnish
request Your
the
Lordship.
payment.
Much obliged, Your Lordship.
Prohibition item number
May I please, Your Lordship? My Lord, I'm appearing on behalf of my senior for R3. Lordship, here the department has already sent us the reconstructed service book, and recently, however, two more documents were required. However, I'm told that the same has been sent to us. Therefore, I pray that 3 weeks' time may be given up to us to settle the case.
This is regarding pension.
Lordship,
2 weeks.
3 weeks.
Okay. Learned Counsel Mr. Wati Jimmer is present for the petitioner. So also heard Ms. P. Monbeni. Monbeni is appearing for the respondent number 3 / Accountant General Nagaland. Stop. The Learned Counsel for the respondent number 3 submits that some documents were required for processing the pension papers of the late husband or father.
Son.
No, that's why father's pension, na?
No, my son pension.
Who filed? Oh, son's pension. What did I say? For processing the pension papers in respect of the petitioner's son. Stop. She submits further that the documents which were required have already been received and the same is under process. So she therefore prays for 3 weeks' time to complete the to complete the entire process. So, list after 3 weeks.
Lordship.
prohibition item number 2.
May I please, Your Lordship? Lordship, here I'm here to file my affidavit in reply. I'm waiting for some instructions, so if this matter can come up after the vacation, Lordship.
Ms. Nika Aye, Learned Counsel for the petitioner is present and has sought for how much time?
3 weeks.
3 weeks' time to file an affidavit in reply to the affidavit filed by the state respondents. So Ms. Ayemi, Learned Government Advocate is present. List the matter after 3 weeks as well.
Much obliged, Lordship.
For orders item number 6.
Yes, anyone? None appears for the petitioner and the matter is called list after the summer vacations.
For orders item number 7.
May I please, my lady? My lady, for the last order, service upon respondent number 6 and 7 are yet to be completed, my lord.
Okay. We'll await or you want to take first steps? We'll wait.
My lord,
Service.
will await, my lord.
Learned Counsel, Mr. V. Devnath is present for the appellant. So the office note dated 23/6/2026 indicates that the service report in respect of respondent number 6 and 7 is still awaited. So, Learned Counsel, Mr. Nongosal appears for the respondent number
1 to 5.
1 to 5. So, list after 4 weeks awaiting service report on respondent 6 and 7. Yes.
Deeply approved.
For orders item number 8, 9, and 10.
Please, Your Lordship. Service upon all the respondents are still awaited.
Still awaited.
Yes, sir. Yes, sir.
Learned Counsel for the appellant, Miss Such and Such present. Stop. The office note dated 23/6/2026 shows that the return service report in respect of respondent 1 to 4 is still awaited. So accordingly list the matter after 3 weeks, awaiting service report on the respondents.
For orders, item number 11.
Please, Your Ladyship. Our office has been asked to take steps upon the complainant. Despite best effort, the complainant could not be reached. I've been informed by the IO that the complainant is out of station. So, Your Ladyship, and more.
But is he a
moreover, Your
resident
Ladyship-
of Nagaland?
Yes, Dimapur. Your Ladyship, in a similar case, it has been the judgment has been reserved. The same FIR is under challenge and the judgment is reserved. So once the judgment is out, then it will have a bearing in this case. So
Different petitioners.
different petitioners, they are the co-accused.
Co-accused,
Yes.
Okay.
So the matter may be listed after the vacation.
After vacation.
Yes.
Learned Counsel Mr. M. Sola is present for the petitioner. Ms. S. Mary Learned PP is present for the state respondent and submits that the steps have been taken, the notice was issued through the IO of the case. However, the IO is unable to contact the respondent number 2 as he is stated to be out of station. Stop. In any, be that as it may, Learned PP submits that do you know that case number?
Yes. I have
Criminal
the,
petition for
I have the order.
States that in criminal petition 43 of 2025, the same FIR which is assailed in the present petition had been challenged by the petitioner and the matter has been heard and reserved for judgment. Accordingly, Learned PP prays that this matter may be listed after the disposal of the criminal petition 43 of 2025. So, list after disposal of criminal petition 43 of 2025.
Obliged, Your Ladyship.
For orders, item number 12.
Mr. Lordship, service upon respondent number 1 to 3 is still awaited.
1 to 3. Learned Counsel for the petitioner Ms. Yoka Kokla. Yoka Kokla is present. So, the office note dated 23/6/2026 shows that the service report in respect of respondent 1, 2 and 3 is still awaited. So accordingly list after 3 weeks awaiting service report on respondent number 1, 2 and 3.
For orders, from the supplementary office, item number 13.
Did you get the case ready?
Yes, Your Ladyship.
Your Lordship, I'm appearing for the petitioner, Your Lordship, the alleged accused,
Okay.
SL Rocky, Your Lordship. And my learned colleague Annie will be assisting me in this case, Your Lordship. Your Lordship, this is a bail application wherein this present petitioner was arrested on 18 March 2026 for a
18 March.
March 2026,
Uh,
and he was sent to the police custody on 19th March 2026. And then he was sent to judicial custody on 26 March 2026, Your Lordship, Your Ladyship. Your Ladyship, now with regards to the ground for the bail, I will directly come without
and what
going
is
into the facts.
section first under which you are booked?
Your Lordship, I'm booked under section 27A, which is for 27A, and Your Lordship, Ladyship, I'm booked for 28 and 29 of the
29
NDPS Act.
is
Your Lordship. Your Ladyship, 27A is for financing and harboring the offenders in this case. 28 is attempt, and 29 is conspiracy, Your Ladyship. Now, in this case, Your Ladyship, this sections itself is not applicable in this case because there is no allegations and prima facie evidence with regards to any amount, with regards to any financing by this present petitioner. alleged accused, Your Lordship. Therefore, Your Lordship, now without going into the merits, I would just like to place Your Ladyship first. My grounds of bail
Okay.
mainly focuses on the ground of arrest with regards to section 47 and 48. There is a violation of 47 and 48. Now, Ladyship, I may take Your Ladyship to page number 62 of my petition, which is the ground of arrest submitted, given to the wife of the accused. The receiving of the wife is below. Received on 18/3/2026, Jarvis. Jarvis is the wife, Your Ladyship. Now, my first submission is that the accused was never provided with the written grounds of arrest. Instead, they gave this notice to the wife, which is a violation of section 47 and the Supreme Court judgments, which clearly states that the ground of the arrest should be given in written to the accused, and merely giving it to the friend or relative does not amount to the compliance of the section 47, and section 47 itself states that the ground of arrest should be given to the accused, Your Ladyship. This is my first argument.
You're on page 62. Page
62, Your
But the
62.
signature of the accused is also there.
Your Ladyship, signature of the accused is there, but there is no evidence to the fact that whether the written this notice has been given to the accused. Now, to prove my arguments,
That's why he signed.
Your Honor, Your Ladyship, to prove my arguments, there is a police remand order at page number 34. Page number 34, annexure P5. In this remand order, police remand order, there is no statement or observation made by the magistrate wherein it says that the ground of arrest has been given. This is a big evidence which proves that it was never given to the accused. This is my first. There is this remand order. Police remand order is dated 19 March 2026, annexure 5, page number 34, which nowhere states in the order that the ground of arrest has been given in written. It also nowhere states that the ground of arrest has been explained or not.
Oh, remand was given by an executive officer.
Yes, Yalla. And it is very clear as per the Mihir judgment that at least
Magistrate
two.
would never miss that out.
Yes, yes, yes. That's the therefore the benefit of that thing should be given to the accused, your ladyship. That's my only submission, first violation. And then, your ladyship, again coming to the same notice, sections, page number 62. Page number 62, if I may take, your ladyship. Your ladyship, in the point number 5, I would just like to read it out. I certify that the above information has been duly conveyed, conveyed and recorded in compliance with the Article 22(1) of the Constitution of India, Section 47, and guidelines of the Honorable Supreme Court. That means this notice is made after taking into concern the three judgments, that is Prabir Purkayastha, Vihan, and Mihir Rajesh Shah. Now, your ladyship, why I pointed out this, I would like to point out para number 2 in the notice. Para number 2, clause 2, and below that there is a bracket. I wanted to state that this format itself is not in compliance of the Supreme Court judgment. This format itself is wrong, your ladyship. It clearly says in the bracket, brief factual grounds of the grounds of arrest attach separate sheet if required, your ladyship. The format itself is wrong. The format itself is not with the compliance of the Supreme Court judgment. When it says that the ground of arrest, brief factual ground of the arrest, attach separate page if required. This is my contention that the whole format itself is not as per the Supreme Court judgment, your lordship. Now, your lordship, this is my second point. Now, third point, your ladyship. Your ladyship, if your ladyship may see the ground of arrest and the reason of arrest given, it is similar and identical in nature. It is
What is
in this notice.
the grounds
It
of
is arrest, grounds of arrest written. The grounds of arrest in point number 2, it is written as that it has been alleged, if I may read it out, your ladyship may have it,
Involved
that
in
you are involved in the sale, purchase, and transporting narcotic drugs from Manipur, Nagaland, and outside Nagaland. Now, reason of arrest also same. You are involved in sale, purchase, and transporting illegal narcotic drugs. So it is identical and similar. And your lordship, this is my third submission. Now, this even if presuming but not admitting that this can be taken as this cannot be taken as ground of arrest, because in the Prabir Purkayastha judgment, it clearly differentiates what is ground of arrest and what is reason of arrest. Your ladyship, if my learned colleague may kindly give the citation of Prabir Purkayastha, I would like to show your lordship ladyship the relevant para in this case.
yes. Yes, para.
Okay. Your ladyship, kindly give me some. Just give me 2 seconds, your ladyship. I did not have the judgment with me. Your ladyship, I would like your ladyship to take to para number 48 of this judgment. Para number 48, just above placenta G. Just above 3 lines above placenta G of para number 48. It says, your ladyship has that page?
Wait.
It's, uh, is the second last page, your ladyship.
Yes.
Yes. Para number 48, your ladyship. This is Prabir Purkayastha, Supreme Court judgment passed by
Yes, I know.
passed on 5th.
Every day we are reading this judgment. Yes, tell me.
Yes, your ladyship. Just above 3 lines above placenta G, it clearly states the reasons would commonly apply to any person who to any person arrested on charge of a crime, whereas the ground of arrest would be required to contain all such details in hand of the investigating officer which necessitates the arrest of the accused. Simultaneously, the ground of arrest in form in writing must be conveyed to the arrested accused all basic facts on which he was being arrested, so as to provide him an opportunity of defending himself against the custodial remand and to seek bail. Thus, the ground of arrest would invariably be personal to the accused and cannot be equated with the reason of arrest, which are general in nature. This Prabir Purkayastha judgment is one of the first judgments. Then Vihan Kumar was Vihan Kumar came, and then lastly Mihir Rajesh Shah came. Mihir Rajesh Shah clearly states that, your ladyship, that at least 2 hours prior to the police
The ground.
remand before the magistrate, the ground of arrest should be given. Now,
Yes.
in this case, only on these 3 issues, the section 47 has been violated, and the Supreme Court guidelines have been also in violation, because this format itself is wrong.
Okay.
And the ground, if presuming but not admitting, if this notice is taken as a ground of arrest, then again it also violates the Vihan judgment, because Vihan judgment says that, if your lady if my colleague can kindly give the Vihan judgment, your ladyship, first page itself, first page, the head notes, your ladyship. Communication of ground of arrest to a relative is not equivalent to informing the arrestee. Arrest memo contains do not include ground of arrest, wake, or foresight. Now, your ladyship, what I wanted to submit with this Vihan judgment is, in Vihan judgment also, not taking to the facts, I'll just state a small fact that in this case also the ground of arrest was given to the wife. And then the Supreme Court says that giving ground of arrest to the wife does not comply with Section 47, because Section 47 clearly states that the ground of arrest should be given to the accused. This is the observation of the Honorable Supreme Court in Vihan Kumar judgment. And Vihan Kumar also again states that what all should contain in the ground of arrest. The relevant para, the conclusion is at para number 21 of this judgment, clause B, page number 11. If I may read it out, ladyship.
Yes.
The information of the ground of arrest must be provided to the arrested person, your ladyship, arrested person, in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands. Now, this conclusion can be divided into three portions, which clearly states that first, arrested person should be given, sufficient ground should be given, and now the sufficient ground differentiates between ground of arrest and reason of arrest is in the Prabir Purkayastha judgment, and the third portion it says in a language, your ladyship. Now, in this case also, your ladyship, if I may just, I'll just show your ladyship one small line only, your ladyship.
BNSS. Yes, yes.
Your ladyship, next page, para number 24. Para number 24, your ladyship.
Yes.
Third para of para number 24, third line, your ladyship. Thus, the stand taken shows that the ground of arrest was not informed to the appellant, but to his wife, your ladyship. This was observed, and then Justice Koteshwar also at the last page also observes, last page of this judgment, your ladyship. Para number 3 of Justice Koteshwar's observation,
Yes.
last page, last 4 lines. Hence, the requirement of communicating the ground of arrest in writing is not only but also to relative or such person as may be disclosed or nominated so as to make the mandate of Article 21 an effective, failing which such arrest may be rendered. Your lady. Now, this is one of my submissions for section 47, your ladyship. Now, your ladyship, I would like to take your ladyship to section page number 63. This is section 48 notice, your lady. Last page of my petition.
63.
63, before the wakalatnama. Your ladyship, this is the information about arrest to relative or friend under section 48. Now, your ladyship, if your ladyship may see, there is no signature of the wife receiving the said information. Even though there is a remark written by the respondent that the wife was present at the time of his arrest.
No,
But there is no receiving. But there is a receiving on 47. But there is no receiving on.
These
Yes.
papers are usually given out together. Okay. They are usually given out together at the time of arrest. So this means that the wife has accepted both and she has given her signature. That's the reason why.
Your ladyship.
They have received both together. We cannot be hyper technical about such things. Anyway, yes.
Your ladyship has also given a judgment in that case only. Your ladyship, if I may show the ladyship.
But each fact and circumstance is different, and we rely on the records, the original records.
Yes, your ladyship. This is also certified copy only from the court only. It's a certified copy. The seal of the.
Each case will be different. Just because the court has allowed in one case doesn't mean that the facts will be same in the other case also. Anyway, what is this? Regarding 47, 48, this one also.
Yes, your
We're
ladyship.
talking about application 33
For-
of 55. Let's move ahead.
This is the judgment of your ladyship only at para number 6, your ladyship. Para number 6, Kholcha judgment, I suppose.
Yes,
This
yes,
is the Kholcha judgment. Huh? The
yes.
present application has been filed on the ground that none of the friend or relative were informed about his arrest after the arrest was made, and therefore the provision of section 48 BNSS has been totally violated. It is submitted that there is no signature of the concerned person, ladyship. On this ground itself, your ladyship has granted bail to this present accused also, not only to this accused, your ladyship, to a co-accused in this case also. To a co-accused also in this case, your ladyship has granted bail. Your ladyship may, Annie, if you can submit Baby Rose judgment. Your ladyship, this is the recent judgment. This is co-accused in this case, same matter. Para number 16, your ladyship, in that judgment. Baby Rose Dauraila, Baby Rose versus State of Nagaland.
No,
She is the co-accused in this present case.
Current counsel, in this case, it was found that the accused had not been provided with the grounds of arrest. Okay.
Yes, your your ladyship, in Kholcha case, your ladyship. Stop. Now in Baby Rose also, this judgment also at page number para number 16. Para number 16. Now this order was based on violation of 47, 36, and 48. There were 3 grounds in this case. So one of the observation made by your ladyship is that para number 16 with regards to 48, with regards to the information of arrest to relative friend under section 48 of the BNSS, the information shows that the elder sister of the accused had informed telephonically about the arrest. However, there is nothing on record to show that the same has been sent to the relative either through post or through other means. There is also no acknowledgement by the relative friend in the said document. Your ladyship, it's contradiction of section 47 and 48, because in a place where signature is not required of the family, they are taking in 47. In a place where 48, in a place
Actually,
where signature of
the signature of the wife should have been at page 63.
yes, your ladyship, this is my only submission. Therefore, and Mihir judgment and Vihan also says that it is the duty of the respondent to prove that they have provided this notice to the family. Now, when there is no signature, there is no evidence to prove. It cannot be said that it has been given to the relative, your ladyship.
Not take any fault with page 62, because there the signature of the accused is there. Okay, but 63, the signature of the wife is not there. That is a fact. Yes,
Yes, your lady.
can we see the case? Is that all?
Yes, these are the main grounds which are there. And 62, not only the signature or the whole format notice itself, I am challenging, stating before your ladyship that the whole notice is not correct, your ladyship.
May it please your ladyship.
Yes.
I have a submission to make, your
Yes,
ladyship.
yes.
Ladyship may kindly appreciate that this is the successive bail application. Now, unless there is change in circumstances or facts, successive bail application is not permissible
On the
under
same ground?
Yes, on the
Same
same
ground.
ground. The ground urged in the present bail application is same as the first bail application. If your ladyship may kindly come to page 58, same ground has been taken. There are 3. Yes,
Yes.
there are 3. Bail is being sought inter alia on the ground that there is no prima facie case against the accused R.L. Rocky, that the provisions relating to arrest under section 36 and 62 and 47 and 48 of the BNSS have not been complied with. that that written grounds of arrest were not furnished, and that he is entitled to parity with co-accused Duraila Baby Roast, who have been enlarged on bail by the Honorable Gauhati High Court Kohima bench. It has also been contended that Section 37 of the NDPS Act is not attracted, as the FIR initially discloses offences under Section 27A, 28, and 29 of the NDPS Act. The counsel for the accused relied upon Prabir Purka Yashtha versus State, para 48 of the Honorable Supreme Court, and that of Mohammad Achuba versus State of Assam, case number bail so and so of the Honorable Gauhati High Court. Now, your ladyship may kindly come to para 6.
Para 6.
Yes, the findings of the court. In the instant case in hand, it is seen that the arrest memo annexure 4, page 31 of the application bears the signature of the witness Kayeso, house owner belonging to the Mao colony where the accused was arrested, which falls within the mandate of Section 36, read with Section 62 of the BNSS 2023. The records placed before the court further disclose the existence of written grounds of arrest, annexure X, page 40, as well as arrest intimation document signed by the wife T.H. Jarvis, who was present at the time of his arrest. So far as the plea of the parity is concerned, parity is not to be claimed as a matter of course and depends upon the role attributed by the accused and the materials available against him. On the materials presently available, this court is not satisfied that the accused stands on the same footing as those who have been granted bail. 9. Having regard to the nature of the accusation, the quantity involved, the materials collected during investigation, and the applicability of Section 37 of the NDPS Act, this court is unable to record satisfaction that there are reasonable grounds for believing that the accused is not guilty of the offense or that he is not likely to commit any offense while on bail. So, your ladyship, the ground urged in the first bail application is same as the present bail application. Therefore, your ladyship, unless there is change in circumstances or facts, bail entering into the merit of the case will be run counter to the decision of the apex
No,
court.
but
And your ladyship, may
violation
kindly allow me to
of
place
47,
one.
48,
Yes, the
can be
judgment of
raised
the
anytime.
your lady, for successive bail application, the Supreme Court's ruling is very clear, your ladyship. Para 8 to 11. May I read, your ladyship? It is a well-settled principles of law that when the successive bail application comes before the court will be very conscious while considering the same, as held by the Honorable Apex Court in State of Maharashtra versus Captain Buddhi Kota Subba Rao, that successive bail application can be entertained by the court when substantial change is established by the accused, which will entitle him for granting bail in successive bail application. The court should not pass the order of releasing the accused on bail in successive bail application, merely establishing some cosmetic changes between time gap of 2 applications. There should be drastic change during the period between 2 applications, which would entitle the accused for bail. In State of MP versus Kajat, Honorable Supreme Court categorically considered that when there are no change circumstances, the successive bail application is nothing but review of the earlier application, which cannot be maintainable. The relevant portion of the aforesaid judgment reads as under. It has further to be noted that the factum of the rejection of his earlier bail application, bearing so and so, has not been denied by the respondent. It is true that successive bail applications are permissible under the change of circumstances. The second application would be deemed to be seeking review of the earlier judgment, which is not permissible under criminal law, as held by this court in Hari Singh Mant versus Harbhajan Singh Bajwa and various other judgments. In State of Tamil Nadu versus S.A. Raja, Honorable Supreme Court has held that when a learned single judge of the same court had denied bail to the respondent for certain reasons, and that order was unsuccessfully challenged before the appellate forum, without there being any major change of circumstances, another fresh application should not have been dealt with within a short span of time, unless there were valid grounds giving rise to a tenable case for bail. Of course, the principle of res judicata are not applicable to bail applications, but the repeated filing of the bail applications without there being any change of circumstances would lead to bad precedents. In the case of Kalyan Chandra Sarkar versus Rajesh Rajan, the Honorable Supreme Court held as follows. Before concluding, we must note, though an accused has a right to make successive bail applications for grant of bail, the court entertaining such subsequent bail application has a duty to consider the reasons and grounds on which the earlier bail application were rejected. In such cases, the court also has a duty to record what are the fresh grounds which pursued it to take a view different from the one taken in the earlier applications.
But the
Your
question
Ladyship,
is when it is a
if I may
violation,
just intervene,
when there are
if I may just,
of Article 21, 22, then it can also always be taken up.
Your
Your
Ladyship,
Ladyship, I may just intervene. In their judgment itself, they have said if the successive bail is before the same judge, Your Ladyship. This is not before same judge, and this is before there is no other section in the BNSS or CRPC to make an appeal. Therefore, the bail applications are filed under the same section which is filed before the district court. And the judgment itself clearly says,
No,
which
in any case,
the learned PP has said, that it should be before same judge.
violation of Article 21, 22. It can be
Yes.
taken. It can be taken up. If it is some other ground, then of course this court cannot take up on the
Your
same
Ladyship,
ground.
our stand is that there is no violation.
Yes,
We are going
for
by
that-
the record. Yes,
for
Your
that we'll
Ladyship.
see the
Yes.
records.
Yes, Your Ladyship.
Eighteen 3/26, 23 years. 18/3/26. 26. Where was he arrested from? Where was he arrested?
He was arrested from Mau Colony, Dimapur, Your Ladyship,
No,
in a rented place, in his rented house. He was arrested from there. And on the day of arrest, also, it may be noted that, Your Ladyship, nothing was seized from his possession.
but you are not pressing that, so don't.
No, Your Ladyship, I'm pressing that. I was only, it's in my grounds only. I'm pressing that in my grounds also. But I'm going into the grounds of arrest. If it is satisfied, Your Ladyship, then I don't need to press all these merits of the case, Your Ladyship.
No, on
It is
merit,
there.
since it's commercial quantity, we cannot, at this stage, we cannot.
Your Ladyship, exactly. But then one more thing is very interesting, Your Ladyship. The sections which are charged does not even mention about the contrabands which are caught. So the sections are charged only 27A, 28, and 29. They said they have caught illegal, this 29 soap cases after 2 days of his arrest
No,
on
during the
20.
period of investigation, this court will not go into it. That is not,
Oblige, Your Ladyship.
that is to be considered by the trial court. Okay. Learned counsel, see, what has happened is you were arrested from your house, okay, at
Yes, Your Lady.
Gauhati village. So your wife was also there at the time of your arrest. So this Appendix A, Appendix B, and then the checklist, they are all given together at the same time, okay. So it appears that Appendix A is the 47 notice and Appendix B is the 48 notice. So and the checklist. So they were all given together, and it appears that the accused has also signed and the wife has also signed. Is that your submission, PP?
Yes, yes. They are urging on the ground of arrest, so it has been complied with. There is no violation.
No, no, Your Ladyship.
See the
On that,
timing also. See the timing also.
Timing is
18/3/26, 23 hours. Both
Your
same.
Ladyship, these are all filled up by the respondent itself. And with regards to that, if they have to give it to the wife, the Vihan judgment also clearly says that it should be given to the, just because the signature is appendix of my accused, of the present petitioner, it does not mean that it has been given to the accused. It is received by the wife,
The
Your
fact
Ladyship.
that the acknowledgement is there by the husband by putting his signature, that means he
Yes,
has
Your,
received. Yes.
Your Ladyship, not only that, even on 48 also there is no signature of the wife. Then only one is given.
Yes.
Sometimes, Your Ladyship, this is the procedure also. We know that there are some,
This is
always
as
some
far
things.
the same documents, same. They're just Appendix A and B of the same documents, which was handed over together. Okay.
Your Ladyship, Appendix A and B is different appendix. What if they have not given it? Only they gave Appendix
They
A
may
to the wife.
see, supposing the wife was in a different place, that is a different issue. In the other case, the wife was not at the place where the husband was arrested. Okay, in one of those cases which you referred, my
Yes,
judgment.
yes,
So in that
yes.
case, the wife was not at the place where the husband was arrested. So they had sent it through. They had called her, and then they had sent it through some other means, perhaps. So that was
Yes,
not
yes.
indicated in the
I agreed.
the CD. So that was a different case. But in this case, the husband and wife were together when the arrest was made, and they were in the house. So this A, B checklist were all provided together to them, and both of them have given their signature. So this is a different matter
Your
altogether.
Ladyship, but then the
Yes,
section 47 has to be given to the accused. Your Ladyship agrees that it is
yes,
it
it was
is given.
given. That's why he is signed. He has received
Then
it.
your Ladyship, my third submission is also that the ground of arrest which is given is not is identical and similar to the nature of the reason of arrest, and the format itself is wrong. It says ground of arrest in brief factual, if required then only given. If required then only given. This is not Supreme Court judgment. And
So,
then
so
below
if
they are
required
saying
to
that
attach separate sheet, so they have not attached since it was not required. That's all.
Your Ladyship, but the Supreme Court judgment clearly says that
This
all the materials which are available with the IO
any
should be
other ground,
given.
any other ground, any other ground. This ground I'm rejecting. Any other ground?
Then Your Ladyship, I would like to go to one ground also. Then Your Ladyship, I would like to take Your Ladyship to page number again 34, Your Ladyship. This is police remand order. Now this remand order is given for 7 days, Your Ladyship, page number 34, from 19 to 25 3 2026. Now, if we see the order, that means that order is given till 25 3 2026. But the judicial custody was taken only in the afternoon of 26. That means he was in the custody without the permission of any magistrate for more than 12 hours. Now, the judicial custody order,
Taken only on 26.
yes, next page itself here, Your Ladyship, next page itself is the judicial custody order, which is given on 26, and the judicial custody. Yes, sir, okay.
Spot on 24.
Hmm. Judicial, yes, Your Ladyship. Judicial custody was taken only after, no time is written over here again. It must have been after the court hours only. After 10:30, because after 12 or 10:30, when the judge has, when the magistrate has said in the court. So there is a time frame of 12 hours from 26 midnight, 12 o'clock till the morning the accused was there without any permission for the magistrate. So this lapses, this 12 hours is also illegal detention, Your Ladyship, because without the permission of any magistrate, they cannot keep the person in police custody. And the police custody lasted only till 25th, 2026. So from midnight of the 25 and 26 till he was produced, there was no permission from any magistrate to keep him in police custody. This is one of my submissions, and therefore there is illegal detention, again violating Article 21, Your Ladyship. Therefore, he may be set at liberty and granted bail, Your Ladyship. More than 12 hours he was kept without any order. The order itself, police remand order itself is very valid and clear that it is still valid till 25. There is no time written. Let's presume that it was valid till 11:59 p.m. at night. But what about the intervening night? Till morning, till afternoon, till the time when he was produced before the CJM Kohima for the judicial custody. That means he was kept without any order or magistrate, any order from the magistrate, judicial magistrate, in the custody of the police, which is again an illegal detention, Your Ladyship. Therefore, on that itself, when the illegal detention has happened, there is violation of Article 21, Your Ladyship.
Okay. Police remand given from 19/3 to 25/3.
25.
And
So
then-
there is no timing for the 25. Let's presume it was till 11:59 p.m. till night. But what about for 26? From midnight 12 till the time he is produced in the judicial custody, there is a gap of that more than 12 hours until the time he was produced before the magistrate to be sent to judicial custody. So that 12 hours is an illegal detention, Your Lady.
Okay.
They should have produced the accused on 25 itself and taken from judicial custody.
Mm. 25. Okay. 25/3 statement was acquisition of accused and custody.
Both the magistrate order is the evidence, Your Ladyship.
Yes.
And then the magistrate also again does not record that whether the ground of arrest is given or not. Again, Your Ladyship.
No, that is done by an executive magistrate, so they have missed out that line.
Your Ladyship, that is the sole reason. That's why I was not been given chance to present through a legal representative. It should have been given to me. If I had the ground of arrest, I would have filed a remand objection, police custody order, and then even in the judicial remand order also, there is no statement to the fact that the ground of arrest is given. That also. So in both the orders, police remand order, judicial remand order, there is no mentioning of ground of arrest. So it might have been manufactured. And then your ladyship, one important, this Vihan judgment clearly says that case diary is not an evidence to the fact whether the accused has been given the ground of arrest or not. Your ladyship, case diary is not an evidence. In the Vihan Supreme Court judgment, it clearly says that case diary is not an evidence.
Okay, this may be a ground because even in the order dated 26/3, nothing is stated.
Yes, your lady. Both in both, nothing is written about the ground of arrest.
Yes, PP. I think we may have to allow because the magistrate in the order dated 19 March as
Yes,
well as
yes.
26/3,
Yes, yes.
nothing is stated that the grounds of arrest have been given to the accused and that the grounds of arrest have been provided to the relative, friend, and all that. Plus, the police remand was only till 25/3, and the judicial remand was taken on 26/3.
Yes, yes,
Yes.
that's it, yes.
So what happened to that intervening
Intervening period, yes, Your
intervening
Ladyship.
period?
We can't go beyond the records. If there is
that is
mentioned in the
the
record,
problem.
then yes, we have to go by that.
Okay. Yes, the instant bail application under section 483 of the BNSS, read with section 37 of the NTPS Act, has been filed, praying for the release of the alleged accused / petitioner. The accused himself is the petitioner. The accused.
Yes, your ladyship.
Shri S.L. Rocky on bail. Huh? Stop. On
Your
bail
ladyship.
in connection with, yes.
One request, if the names in the Wakalatnama may be reflected in the order, your ladyship.
You give it in,
All the names.
write it down and give it for the release of such and such in connection with special case number 6/2026 arising out of narcotic PS case number 3/2026 under section 27A/28/29 of the NTPS Act. Stop. Para. Learned counsel, Mr. Such and such, and then you take down their names, okay? For the petitioner. Stop. Also heard Miss S. Mary for the state respondent. Stop. Para. The brief facts leading to the filing of the instant application is that the petitioner / accused was arrested on 18/3/2026 in connection with the above mentioned case and was remanded to police custody by an order dated 19th March 2026 from 19/3/2026 to 25/3/2026. Stop. Thereafter, the Chief Judicial Magistrate Kohima, by an order dated 26/3/2026, remanded the accused / petitioner to judicial custody. Stop. Para. In your pleadings, where have you taken that? Which para? Regarding the 12 hours intervening period? Acha, anyway, before that, you just say it is also stated that the present petitioner / applicant / accused had filed a bail application on 11/6/2026 before the learned special judge NTPS Kohima, Nagaland, and the same was registered as IA 107/2026, however, the same was rejected by the learned trial court by an order dated 18/6/2026. On the ground that where is that order of, okay, on the ground that on the ground that the case pertained to seizure of commercial quantity of heroin slash brown sugar, and that the court cannot ignore the materials collected during investigation, and also the applicability of section 37 of the NTPS Act, as the case involved a commercial quantity. Stop. The learned trial court also observed that there was no violation of section 47 and 48 of the BNSS as far as the records were concerned. Stop. Being aggrieved, the petitioner slash accused is before this court. Stop. Para. The grounds taken by the petitioner slash accused in the instant case is that two grounds of arrest were provided to the accused person at the time of his arrest. Until date, it has not been provided. It is stated that the wife of the accused slash petitioner was provided with notice regarding grounds of arrest under section 47 BNSS, and further that the said notice under 47 BNSS is totally against the guidelines laid down by the Supreme Court of India. Stop. He has submitted that the section 47 notice is signed and acknowledged by the wife of the petitioner and not of the petitioner accused and not the accused person, and that the section 48 notice is also not acknowledged and signed by the wife of the accused person. And therefore, the arresting authority has violated the provisions of section 47 and 48 of the BNSS. So, para. Another ground which the petitioner slash accused has taken herein is that in your pleadings,
Your Honor, that ground of the 12 hours has not been mentioned in the pleadings of my grounds, but if it may be recorded that the same has been orally submitted,
okay,
and also the documents are also
okay, yes, just,
annexed along with it.
okay, what did I say starting? Is that even though it is not mentioned in the pleadings, however, he has made an oral submission regarding the fact that there has been illegal detention of the petitioner slash accused for about 12 hours, inasmuch as the first order of police remand dated 19 March 2026 clearly indicates that the remand was only till 25/3/2026. Stop. The order of judicial remand was made only on 26/3/2026, and accordingly, from midnight of 25/3/2026 till the time when the order dated 26/3/2026 was passed, there was no permission or order of any magistrate remanding the accused slash petitioner either to police custody or to judicial custody, and accordingly the period in between is to be treated as illegal detention. Stop. Another submission of the learned counsel is that neither in the order dated 19/3/2026 nor in the order dated 26/3/2026, which are the orders of police remand and judicial remand respectively, there is no mention, there is no statement made that grounds of arrest had been provided grounds of arrest had been provided to the provided and explained in a language understood by the accused. And on this ground alone, the instant application needs to be allowed. Stop. The petitioner has relied on the cases of, and you write number one, Rabir Prukayasta versus State in City of Delhi. I'll give you the cases later, huh? 2024 8 ECC 254. Then number two, you write Vihan Kumar versus State of Haryana and another 2025 ECC online AC 269. And then yes, only two. Then para learned per contra learned public prosecutor S. Mary, by relying on the case diary and the records available, has submitted that the provisions of section 47 and 48 of the BNSS have been complied with, inasmuch as the wife was also present, inasmuch as the alleged accused was arrested from his house, wherein the wife was also present, and that the section 47 BNSS notice and the section 48 BNSS notice, along with the checklist under section 35(1) BNSS, are all part of the same set of documents, being given to the accused and the wife as annexure A and B, and therefore, upon acceptance and receipt of the same, the wife of the accused has acknowledged by putting her signature. Stop. The accused person has also put his signature by way of acknowledging the receipt of the grounds of arrest at the Appendix A / notice under section 47 BNSS. Stop. She has submitted that the time and date of receipt of the section 47 notice as well as 48 BNSS notice is the same and identical, as they were both received on 18/3/2026 at 23 hours. So this goes to show that the accused as well as the wife of the accused person has already received the notice under section 47 and 48 of the BNSS. Learned Counsel, Learned PP, by relying on the case of Abhishek Sharma versus State of Himachal Pradesh, in order dated 8/8, what is this? 8/8/2025, na? Order dated 8/8/25, reported in 2025 HHC 26852, submits that without any change in circumstances, a second application for bail is not maintainable. Stop. She has submitted that even before the trial court, the same grounds had been taken by the present petitioner / applicant praying for bail, and the same has been rejected. Stop. And even before this court, the petitioner has urged the same grounds, and therefore, without any change in circumstance, and by taking the same grounds, the instant application is not maintainable. para. This court has given its due considerations to the submissions made by the learned counsel for the parties, and also produced the pleadings as well as the case diary. So, para. Upon a perusal of the case diary, it is seen that the accused was arrested on 18/3/2026 at 23 hours from his residence at Kuda B village, Nagarjan, Dimapur. Stop. It is seen that the accused has affixed his signature in the grounds of arrest, and therefore it cannot be said that the grounds of arrest were not served on him. So, as far as the section 48 notice is concerned, the same is shown as appendix B. Earlier, in that 47, you say in brackets appendix A. Okay, appendix A. That 47 grounds of arrest will be appendix A. Then appendix B, the 48 BNSS notice, which is shown as appendix B, is seen to be a part of the same set of documents which was served on the accused and his wife at the time of his arrest, as they were together in the house. Stop. Accordingly, it is seen that the wife of the accused person has received the appendix A / 47 notice, section 47 notice, and appendix B / section 48 notice, section 48 BNSS notice, at the same time and date by giving her signature on the appendix A. Stop. Therefore, it cannot be said that the mandate of section 48 BNSS has been violated. Hence, this contention of the petitioner is not accepted. So, para. As far as the submission regarding the illegal detention, this court has perused the order dated 19 March 2026 as well as the order dated 26/3/2026. So, in the order dated 19 March 2026, the learned executive magistrate Kohima has not stated anywhere that the grounds of arrest have been provided to the accused person as well as his relatives. So, what is pertinent also is that another pertinent point is that the accused person has been remanded to police custody with effect from 19/3/2026 to 25/3/2026. So, however, the judicial remand was granted only on 26/3/2026 by the learned Chief Judicial Magistrate Kohima, Nagaland. Stop. Even in the order dated 26/3/2026, there is no indication as to whether the grounds of arrest have been provided to the accused person and his relatives. Moreover, there is no explanation regarding the period from midnight of 25/3/2026 till the time when the judicial remand was granted on 26/3/2026. Stop. In view of the above observations, comma, this is well different para, okay? In view of the observations made herein above, comma, this court is of the view that the violation of Article 21 and 22 of the Constitution of India has been made out by the petitioner slash accused person. Stop. And when violations of Article 21 and 22 are established, it will be a ground to grant bail, even if the statutory restrictions on the grant of bail exist under Section 37 of the NTPS Act. Stop. Para. For the reasons mentioned above, comma, the accused person, Shri S.L. Rocky, is allowed to go on bail under the following terms and conditions. Number 1, execution of bail bond of rupees 50,000 with one surety of like amount, who shall be a local resident of Kohima, to the satisfaction of the learned trial court. Number 2, the accused shall appear before the investigating authority as and when summoned. Shall appear before the investigating authority once a week till the investigation is completed. So, number 3, shall not tamper with the investigation or try to influence the witnesses either directly or indirectly. So, next, the accused shall not leave the jurisdiction of the court without permission from the court. Next, the accused shall provide photocopies of his ID as well as his residential proof before the investigating authority, and shall also provide 2 phone numbers where he can be contacted at all times. With the above conditions, the application stands disposed. Yes.
Oblige, your ladyship.
You just return this, okay?
May it please your lordship.
Yes.
Your lordship, in item 11, your lordship, there's an interim. Lordship.
Item 11.
Yes, your lordship.
Item 11.
Let the interim continue till the next date of this.
Okay, item 11 file is taken away. We'll just check her. No, you check the file. If there is an interim, you extend it till the next date.
Lordship, 24/3 around
We are
26.
being very careful now because
Lordship.
we have discovered something.
Yes, your lordship. Lordship, it's dated 24/3 around 26 days.
24/3.
Yes, your
24/3,
Around
2026.
March of it.
If it's there, we'll extend it. This one you put it inside. Then this one also. This one, did you get the case ready?
Yes, I have.
May it please your lordship.
This is also on what ground?
Your lordship, I'm seeking this bail application on 2 grounds, your lordship.
NTPS.
No, your lordship. IPC is 63, 103, IPC, read with 4, section 4 of Boxo Act.
Okay. Oh, POCSO.
Yes, your lordship. Your lordship, I'm seeking this bail application on 2 grounds. The first ground is your lordship, on the ground that there is a violations of fundamental rights under Article 22, one of the constitutions, and Section 4.